you argue that there is some limitation on what uh, a court can do vis-a-vis uh, setting uh, appointing conservators, uh, setting the rights of conservators, and determining any access less than 50-50. Is that have I summarized your so far what your concerns are based on page 6 through 8? Dr. Connor?
Yes, sir. And yes, sir. If I may add, with your permission,
You may.
briefly.
It's your
I
motion.
think it's also, yes, sir. I believe. Thank you. I think what you have just summarized is also, in addition, supported by Texas legislation, even in the Family Code in Section 15103, in which it stipulates limitation of state agency action, not imposing upon fundamental liberties or protections of the individuals of the state. And as you know, and I think you've already said that very clearly, that even your oath of office supports supporting the Constitution of the United States. There are several Supreme Court cases that, out of judicial efficiency, I'm not going to go into detail. I'm sure you're very familiar with, that support the protections of individuals, not only in association but in due process. Uh, and that to be put in a position advocating for a child under the best interest standards actually can put the judiciary in a non-biased, in a non-neutral position rather than a neutral position. As you may know, Your Honor, it is arguable that the best interest doctrine is even valid. As you know, Your Honor, other terms such as co-parenting really have no defined definition. But I think you had summarized it pretty well. For judicial economy, I'm not going to go into all the case law of this. Um, I believe that if it's of interest to you, you will do it yourself, unless you would like me to proceed.
No, that's fine. I just want to go through this your motion and see if we can work through it, at least so I can understand it, so I can rule on it at some time. So I'm moving
Yes,
on
sir.
to page 8, uh,
Okay.
uh, and I'm looking at objection 3 uh, of proceeding with any request by respondent. That's Ms. Ho, to limit the rights. Uh, okay, I understand objection 3, objection 4, unless you would like
If
to
I,
comment on objection 3, sir.
yes, sir. So if I may, so me as the petitioner, basically asking the court to take judicial notice of the Family Code 1510303, as I previously mentioned, limitation of state agency action. Take
Court
and
will so.
asking to take judicial notice of the holding in Troxel versus Granville, which, as you may know, is not just about grandparent rights, but was about the rights of the parents that precedes the right of the judiciary to decide what's best for children. The petitioner asked the court to take judicial notice of the court's many holdings in the state's asserted interest may not be broad, sweeping interest, such as broad assertion of acting in the best interest of the child, but that a state's asserted interest must be narrowly focused and asserted on the same plane of generality as the right being infringed. And that case law is cited on page 8 of Employment Division, Department of Human Resources, Oregon v. Smith. I object to this court's proceedings with any request by respondent to limit the rights or impose duties upon petitioner, except where respondent has justified such request by demonstrating a narrow, compelling state interest, that the statutes authorizing such requests are narrowly tailored, demonstrating relief requested is the least restrictive relief available to the court, sufficient to achieve narrow, compelling state interest. An example in this particular case early on in temporary orders was that due to the perceived conflict
Slow
among
down,
the parents.
slow down just a little bit.
Yes, sir.
We got the court reporter, and we need to,
I'll slow down. My
in about,
apologies.
no, that's fine. That's, in about 5 minutes, we're going to take a very short break. But go ahead and finish your thoughts on this particular section, please, sir.
So in that particular section specific to the case was a temporary order back in March of 21, in which due to the perceived conflict between parents, the child was disallowed to have any type of school lunch. School lunch, a activity that is legislated in by Texas that children can have as part of what's called a school activity. A more narrowly tailored restriction may have been to designate a parent and the child, giving the child the ability to have lunch with the parent on rotating every other month, rather than simply abolishing the child's ability to have school lunch with their own parent, was a specific example. Again, going to objection 4, objecting to the court's proceeding with any request by respondent to limit the rights or impose duties upon petitioner based upon broadly articulated best interests of child justification, but objects to all but mostly narrowly tailored justification for proceeding with the request to infringe upon petitioner, and I would say also respondent's fundamental rights. And then further down the page refers to the Palmer standard, Your Honor. As you know, the United States Supreme Court has held in child custody mediation cases between fit parents incident to divorce that the trial court is a state actor acting under the color of state law and consequently limited by the federal Constitution. The trial court's viewpoint regarding the best interest is insufficient justification to infringe upon fundamental rights, and that there are harms to children that are non-justiciable in custody cases. In regard to harm to the child, children face all kinds of harm that does not require litigation or to appear in front of any type of court. All kinds of harm can occur with children in married situations. The same type of harm can occur in children in unmarried situations. Although parents are constitutionally protected in their privacy choices regarding marriage and family living arrangements, can't be punished or burdened by presuming they convey authority to the court to create standards of harm that only apply to litigants in non-married or divorcing situations. The best interest of the child standard does not provide judicial authority to create ex post facto determinations of what constitutes harm to the child. The best interest of the child standard does not provide judicial authority for a court to define harm based upon this court's own viewpoint regarding matters of conscience in child rearing. And please keep in mind, Your Honor, that this does not focus particularly on this court or yourself. It's a general description of court. The petitioner asked the court to take judicial notice of the Palmer standard in its holdings as controlling precedent in this case, limits this court's discretion to infringe upon constitutional rights of the litigants. And it refers, of course, to the Palmer case. The actions, which states the actions of state courts and judicial officers in their official capacity have long been held to be the state action governed by the 14th Amendment, and it cites Shelley v. Kramer. Public officials sworn to uphold the Constitution may not avoid a constitutional duty by bowing to the hypothetical effects of private racial prejudice that they assume to be widely and deeply held. The petitioner asked the court to take notice of its statute as a state actor acting under the color of law in the proceedings. The petitioner asked the court to take notice of the United States Supreme Court Justice Thomas and Scalia's statement in their concurrence to Grutter regarding the Palmer standard. Our Palmer holding. Basically, even a greater governmental interest involves the sensitive role of courts in child custody determinations. The court held that even the best interest of the child does not constitute a compelling state interest. The petitioner
All right.
asks or objects to any
Dr.
findings by the court
Dr.
that
Dr.
Palmer
O'Connor.
is not controlling on the court in the case.
Dr. O'Connor.
Petitioner objects to, yes, sir.
Dr. O'Connor. First of all, you are simply reading verbatim from your motion. And
Yes, sir.
with all due respect, I can read. So I really don't need you to read verbatim from the motion. What I need you to do is summarize the argument that you have concerning those points in the motion without necessarily reading them verbatim.
Yes, sir.
And I didn't mean that remark to be snide or any or pejorative in any manner. And if you took it that way, I apologize.
No, sir, I
But
didn't. I didn't take
now,
it anyway.
we need to give the court report a little break. I need to take a little break. So we're going to stand in recess until 10:45. Now, when we come back, I want to finish up this motion no later than 11:30 or 11:40, and then we can move to Mr. Thompson's motion to withdraw and hear from him and Ms. Ho on that motion. So that will kind of be our schedule. So we'll stand in recess until 10:45. You stop my video?